Does your son like theme parks? Mario, things like that? That new Epic Universe? It's cool. We went for the preview. It was really cool. We're going back in 2 weeks. But yeah, it's really the amount of like creativity stuff they put into the Super Mario. It's crazy. And you go through these portals, and it's like you're immersed in the land. Like it's really top notch. Yeah. My kids are not Disney kids. We took them once, and if we were there 3 hours, I'd be shocked. My husband and I were pissed. We're like, never again.
For what?
He'll help you when he wants to. And then yesterday was a good day. He's not in the mood.
In our office with the printer, it was like $800.
You're at the hospital. Yeah. Maybe 300.
Good morning. Oh, please be seated. Thanks so much. Great to be back at Lee Health. Great to be back in Southwest Florida. I want to thank everybody for being here for today's announcement. We are joined by a number of folks, many of whom you know. We're joined by our great Florida Surgeon General, Dr. Joseph Ladapo. We also have the President and CEO of Lee Health, Dr. Larry Antonucci. Dr. Nick Panetta is the Chair of Department of Plastic Surgery at USF Health and faculty at the Moffitt Cancer Center's Center for Women's Oncology. We have President of the Florida Justice Reform Institute, William Large, President and CEO of the Florida Hospital Association, Mary Mayhew. Where's Mary? I didn't see her. Okay, yes, and then Andy Boland's a partner at Boland Law Group. Before I get into some of that, I do want to point out that recently, I think it was 2 days ago, the HHS and CDC removed the COVID mRNA shot from the childhood immunization schedule, and I think that was the correct move. But I also think it's something that Joe Ladapo had been talking about for a couple years, just based on the data that we had, based on what we knew about COVID, what we knew about the mRNA shots, and how that got added was not evidence-based. It was more just basically following whatever the narrative was at the time. So when he came out for that and Florida was there, oh my gosh, the wailing and the carping and everything like that. But the reality was, you know, his job and our job is not to just follow the crowd or follow narratives, but to actually follow the evidence. And that's what Joe did. I think that's what they're doing now. And I mean, I think a lot of parents got it because the uptake was incredibly low for this, because they saw that there was not a proven benefit. I don't even get into whatever negative effects would be. There wasn't a proven benefit. So I want to thank him for his leadership there, and I'm glad that now we're seeing that reflected in Washington, D.C. Now, we are here today to discuss one specific issue regarding medical practice and litigation. But before I do that, there's kind of a broader context that we're here. Since I've been governor, we have worked, when I became governor in 2019, Florida was considered what they termed it a judicial hellhole. And part of that is because we had an activist judiciary, which really wreaked havoc in this state for many, many decades across a wide variety of issues. When I became governor, though, there is a 7-member court. It was a 4-3 split in the wrong direction. 3 of the 4, though, had mandatory retirement. So when I got sworn in, they had to leave the court. So I was able to make 3 appointments, and we've really transformed the court from that activist bastion where good reforms would just be batted down, more on political grounds than anything, into one that's much more predictable in upholding the law. And that's not even true in a medical context. It's true in the business context. It's true in individual freedoms as well. So that really, the Supreme Court change was absolutely huge. And there have been things that had been passed by voters in the past many decades that court would nullify effectively, and then the legislature would do a lot of things and they would nullify. So those days are over, and that effectively ended judicial activism in the state of Florida just my first month in office. But we also had the fact that Florida was a haven for frivolous litigation. And there are times when people's rights are at stake, people have been harmed, and they have every right to go into court and to seek compensation. But what happens is that when you have the floodgates open, there's an incentive for lawyers to bring cases, knowing that if someone sues you, even if you are 100% in the right, just the cost of having to defend that can be very, very prohibitive. And so a lot of times, if lawyers drive cases, it's cheaper for you to do a settlement, even if you did anything wrong, because taking it all the way to verdict, and if you win 100%, you had to pay all these fees for attorneys and for defense just to be able to effectively show that you weren't in the wrong at all. So that creates a lot of distortions in the economy and medical practice. It imposes costs on our economy and our society. And certainly we've seen things like auto insurance rates and things of that nature driven in large part because Florida had been such a haven for so many litigation and really earned that moniker as being a litigation nightmare. We have done a lot over the years to do really significant litigation reform, and that goes all the way back to 2019 when we curbed the unchecked use of so-called assignment of benefits that allowed third-party contractors to sue insurers directly. That drove up costs and clogged the courts with really a flood of lawsuits. And you think about it, it's like you have a policy, you have a claim, and this becomes like a cottage industry to assign that benefit and this and that clearly got out of hand. So the legislature was able to pass legislation I signed to curb that. We also continued to build off that in 2021 and 2022 with reforms to how property insurance litigation has happened. And basically, Florida was one of a few states that said if somebody sues and they win, then they get attorney's fees. But if they sue and they lose, the other side does not get attorney's fees. Well, that's a major incentive to bring litigation. And so that is not free. That imposed costs. As those costs are put through the system, that helps drive the price that people pay for normal products and the premiums that they pay for that. So that had been something that had been very difficult to do, and yet it's now been a little more than 2 years since those insurance reforms were done, and the results are S&P Global said in 24, the first full year that was in effect, Florida had the lowest increase in property insurance in the entire country out of all 50. Who would have thought that? And the reason is just because you're removing this incentive to litigate even when there really shouldn't be litigation. It makes it less costly. That's why so many people are coming in to do business in Florida. California, they're all leaving for insurance. Like the people that had the fires, they're leaving. Florida, we've had companies moving in since these reforms. Who would have thought that? This is a state that's the most complex insurance market for property in the country, maybe even in the world. We've had 6 major hurricanes in 7 years. I know people in Southwest Florida are very familiar with the last few years in particular, and yet, so far this year, you're basically seeing the rates be stable. You haven't seen them go up 30% like they were prior to these reforms. So that's something that's been meaningful. It has added stability. You have seen more people come into the market. There's just no question that that's the case. Then the following year, 2023, the legislature passed and I signed a broader tort reform and litigation reform, even outside the context of property insurance. And that, I think that's had, people could tell you, small businesses, it's had a positive effect here, but on auto insurance rates. So far this year, the average auto insurance from the major companies is down 4 or 5% in Florida. It's up almost everywhere else, and auto insurance has been the #1 inflationary item across the country over the last 4 years, and the only reason Florida saw a decrease, our drivers aren't getting any better, I can tell you that. It's a tough nut to crack, it just is. But the reason why is because of the litigation reform. I mean, that's the reason why. And you talk to any company, why are they able to offer more affordable rates? Well, it's because we've removed the incentive to litigate first and ask questions later, and that has reduced costs throughout the system. So this has been a lot of heavy lifting. There have been people that have been involved in Florida government and the political scene for like 25 years who've been trying to get legal reform to get us more in line with what works. And you can see some of these things in different parts of the country. Texas did litigation reform, and they had positive results. Other states, honestly, even states like California have done some that you wouldn't think, but even they have done in certain areas. So that's what you do. Now, for whatever reason, even though all these Republicans in the legislature have voted for these reforms and they've been praised for the reforms, you had a movement in the House of Representatives to undo the tort reforms that have been done and enacted in Florida and that had shown to have produced stability in some of these really, really tricky markets. And it failed in every instance except one to even advance past the House. The Florida Senate said they wouldn't consider it. I was not going to support what they were doing. Now, the one bill that they did was a bill to undo legal reform and tort reform. Not anything that was done under my tenure, though, something that had been done many decades ago in the early 1990s when Florida was facing a crisis in malpractice insurance premiums and lawsuits that were driving premiums high. Physicians were leaving the state. It really had a bad impact on access to care. So the Florida legislature overhauled how medical malpractice actions are done in these instances of the wrongful death. And what they did was they did something that some states also do. I think it's a minority of states that have Florida right now. I think it may have been some more at the time. But what they basically said is, medical negligence, obviously you have a right to go in and get compensation. If something happens to you, of course, you can do that. But they limited two instances to where you could sue for economic damages, but you couldn't sue for so-called non-economic damages. And those two classes were if you had an adult child age 25 or older who was not dependent on a parent with no surviving spouse. If you had an action, that 25 or older independent child could sue and get economic damages, but they could not sue for so-called non-economic damages. And the same would apply if a parent was suing on behalf of a 25 or older minor or child, independent child with no surviving spouse or no heirs. You can sue for the economic damages, but not. And the question is, well, why did they do that? And they did it because when you talk about economic damages, those are quantifiable. You can say you were harmed, here's the damage, and you can recover. When you do non-economic, it is basically what a jury wants to award. Now, that's something that's very appealing if you're a plaintiff's attorney, because if you can get a contingency fee out of a big award, you can make millions and millions of dollars potentially on an individual case. So it was the legislature's view that limiting to economic damages would be a deterrent for cases being brought, across kind of in large numbers, right? And so that had been the law in Florida for many decades. What the legislature did this time is they repealed that portion of the medical malpractice reform. And, for me, I think that if we have a right to expect that physicians are going to meet appropriate standards. There's a lot that goes into it. I mean, the state of Florida provides a lot of support for training physicians and everything. And if somebody is careless, and certainly even worse, there needs to be accountability. But I think the question is in a case like this, what's the best way to do that? Is it to open floodgates for non-economic damages, knowing you're going to get a lot of lawsuits that are going to be brought against a lot of physicians who weren't necessarily negligent, right? Because when you're practicing medicine, you can do everything right, and you may not get a good outcome with the patient. There's not a warranty of cure. These are difficult things. Sometimes there's pluses and minuses for what a physician would do. Physician will consult the patient, tell them that here are the options, and sometimes a patient will opt for a course of treatment or a surgery, knowing that there's high odds that it may not be successful. And all these things are very sad, whether the physician was perfect or whether the physician was not. If somebody doesn't make it through that, that is a tragedy in one form or another. And the loss for a family member, even someone that's an adult and independent at that point, is real. And I think everybody appreciates that. I think the question, though, is what would this legislation do for costs of health care in Florida, access to care in Florida, and our ability to recruit and keep physicians. And I know you're going to hear from people today, but it's their judgment. It's also my judgment that if this legislation would be enacted, it would lead to higher costs for Floridians. It would lead to less access to care for Floridians, and it would make it harder for us to keep, recruit, and maintain physicians in the state of Florida. And we need more as it is now. The state's not shrinking, it's growing, population continues to age. You're going to need more and more there. So what could have been done that would have made this acceptable? Well, I think two things could be done. One is focus on holding the physician directly accountable with regulatory actions. See, you do a malpractice suit, the physician doesn't pay it, it's the insurance company that pays it. So it's not a perfect or even a great deterrent for medical negligence. A third party is paying the costs. We have disciplinary procedures in place, but if there's ways to do that so that folks are held accountable, I'm all for that. The other thing that can be done to prevent this from opening up the floodgates of a lot of litigation is put caps on the damages. If you want to do non-economic damages, put caps on the amount of damages and cap the amount that attorneys can recover. If you do that, then you are totally disincentivizing frivolous lawsuits, because they'll know there's a limited amount that an attorney is going to be able to recover. And if you think about it, if you have no caps on the non-economic damages, that is an incentive to bring a lot of cases, and many of them probably won't be successful, but even then you can probably get a settlement. Again, even if you haven't done anything wrong, there's going to be an incentive to settle, because it's very costly to go through with all this. And then, of course, if you can get a jury to do a big verdict, then the lawyer's going to get a lot of the money there. And sometimes, they're getting 35% of what would be awarded to an individual client, or in this case, one of the relatives. So that will incentivize more lawsuits. I'm very much convinced of that. So I told the legislature this going by, and I know they did try to do a cap on the non-economic damages. So they're opening that up, but capping it, and then also limiting the amount that attorneys can recover. If you did that, I don't think you would see a major impact on the healthcare delivery system. I don't think you'd see a major impact on malpractice insurance rates, and I don't think you would see a major impact on access to care. But the legislature did this years ago for a reason, because they were responding to something that was spiraling out of control, and I don't think that what they've proposed here is going to put us on the strong foot without these additional safeguards. So for that reason, I'm announcing that we will be vetoing that legislation. I have been in contact with some of the legislators, particularly in the Senate. I think the change to do the caps failed by one vote in the Florida Senate, and it was something that was, there's some people that don't want to change this at all, but I think of those people, that's something you can live with if you have some caps on it. So if you look around the country, Florida is a minority that says no recovery in these limited instances for non-economic damages, but the vast majority of state have caps on what can be recovered in terms of non-economic damages. And if you don't have those caps, then you really are incentivizing a lot more litigation to take place in the state of Florida. None of that is free lunch. Somebody will have to pay for it. And unfortunately, I think if this bill became law, I do think the cost would be borne by the physicians who would potentially flee the state, to people that wouldn't have as much access to care, and then also to the cost that would go up as a result of it. And we consulted a lot of folks that are involved in the healthcare sector, and I think it was pretty much unanimous that the way this current bill was structured would not have a positive impact on healthcare in Florida and could potentially have some really significant negative impacts. So I want to appreciate everybody that provided their feedback on this. Yeah, they were one vote away from doing something that I think was a little bit more palpable for a lot of folks, but it just didn't end up working out that way. So I'm going to let some other folks talk, and then we'll take some questions. So we'll start with our Surgeon General, Dr. Joseph Ladapo.
Thanks, Governor. So good morning, everyone. Oh, there are more people in the room than I realized when I came in. Happy to see you guys. This is such a beautiful part of the state. I have had the privilege of flying in with the governor this morning, and this part of the state is just, it's really, really gorgeous. So, we're talking about this legislation. The governors make a decision to veto it, and one of the things that I appreciate the governor. I like the guy a lot. But one of the things that I really admire about him, and a lot of other people do too, and it's a major part of why he's been so successful, is because he is able to demonstrate leadership. And you would think we have a lot of leaders, right? Leaders in name in this country, right? Every city's got them, every county's got them, every state's got them, every country's got them. But unfortunately, there's such a shortage of leadership. It's like looking for water out in the middle of the Mojave Desert or something like that. There's just such little leadership out there, and it is a travesty. And and what does leadership mean? Leadership means doing what you authentically believe is the right thing to do. And what is the right thing to do? Well, most people never actually answer that question who are leaders. Right? So they do what most everyone else is doing, and they go the direction most everyone else is going. And the governor, I was very happy that Secretary Kennedy and other members of HHS leadership, like Dr. Bhattacharya and Dr. Makari, made the announcement that they would be pulling the mRNA COVID-19 vaccines from the childhood schedule, and May 2025, we finally had that announcement, and we made that announcement almost 3 years ago, and it was the right thing to do then. It's obviously the right thing to do now, belatedly, but it's absolutely the right thing to do, and that's what leadership means. It means doing the right thing, and boy, I don't know how many people remember that announcement, but we heard about it. We heard about it, quite extensively. I got many earfuls for a while about it, but it was the right thing to do, and it was something that the governor and I had discussed, and it was very clearly the right thing to do based on the evidence. And this is a different issue, but it's also the right thing to do. I went to medical school. I went to medical school at Harvard. I've been in the news a lot lately, and I did a doctoral degree there also, a PhD in research science. And oh goodness, why the heck did I bring that up? Give me a second here. My thoughts are going to catch up with me in a moment. So I can't remember why the heck I brought that up. So I really can't remember. It's throwing me off. So no, that's not it. All right. So so with this issue of the reforms and this veto decision, the lawmakers, right? So I went to medical school because that's my area. I'm a science guy. It nourishes me. It energizes me. I like to do that. My parents had mentioned law school to me when I was younger, and that was not the right direction for me, and I didn't go that direction. So I'm cautious as I talk about legal things because it's not at all my thing. I'm just absolutely not an expert in that area. But I've been reading about different policies that different states have in this area of tort. And it's a tough area, right? Heart goes out to patients and their family members. It's obviously very difficult. And, as an aside, by the way, I'll share with you that the scientific research shows that probably one of the biggest predictors of lawsuits is, unfortunately, having terrible bedside manner. Patients, by and large, know that things don't always go well. And, you know, and most patients are actually very understanding as long as the physician is really has humility and humanism around it. But when doctors are jerks, that's when they get in trouble. That's probably the biggest predictor of legal action. And, you know, that's an issue for the medical profession to work on. I mean, that's an important issue in the medical profession, undoubtedly. And, you know, many of us have seen many examples of poor bedside manner. But even that aside, the issue of justice, legal justice, you know, economic damages, non-economic damages, there simply isn't enough justice to go around and have the system be able to stand up on its 2 feet. It's just not possible. And the right thing to do, just the wise thing to do in that situation is to have caps. Frankly, it's insane to have a system with no caps on non-economic damages and expect for that system to continue to sustain itself and function as it was intended to function, which is to provide care for patients. That's just not possible. And so that has to be there. And, you know, fortunately, we have the leadership of Governor DeSantis